And welcome to the Aaron Katzman Show. I'm your host, Aaron Katzman. We speak for your life, your money, and your investments. And as always, we're coming to you from the spiritual and soon-to-be financial capital of the world, Jerusalem, Israel. If you like this content, please hit the like button below. If you've not yet done so, please subscribe to both the podcast and to the YouTube channel. And if you think somebody will actually get something out of this content, right? They'll be interested in this content. You can go ahead and actually share it with them. It's like this new thing on social media. You can actually hit share and send it to whoever you want to. And that would be really helpful if you do that as well. So we are continuing on speaking about estate planning, retirement planning, estate planning. And it's my honor to bring back to the show Ariel Rosenzweig, who's an elder law and trusts and estates attorney and the managing partner at Eli J. Rosenzweig and Associates, located in Elmsford, New York. He brings more than 13 years of experience assisting families in all aspects of elder care law, including trust and estate planning, administration, litigation, tax cancel, asset protection, and special needs planning, Medicaid, Medicare guardianships, long-term care planning, spousal recoverability claims, and Medicaid lien resolutions. Ariel, welcome to the show.
Hello, Aaron. Good morning or good evening to you.
We can't tell. It's a little bit still sunny outside, so we're leaving all the watchers and listeners in suspense. Nobody knows what part of the day it is. So I want to just jump right in. A lot of people ask me, should they do a will? And then once they say, okay, we'll do it, they said, well, should we have an executor? And if we should have an executor to the will, who should that be? So my question to you first of all is, what is an executor? What is the position of an executor? And how should you go ahead and pick one when you're setting up your estate?
Yes, so that's a great question, Aaron. The answer to the question about what is an executor is an executor is the fiduciary. They're the one responsible for managing an estate, for administering to estate, for distributing estate assets. But an executor is appointed by the court. They're nominated by a person while they're living, and then they're appointed by the court to administer to that person's estate upon their death. So you are not automatically an executor when someone dies. You have to be appointed by the court. So depending on where you live and who the executor you want to serve is, and all sorts of other financial questions will determine whether you should, in fact, manage your estate, your United States estate, via a will, or whether you should do it via some other vehicle, such as a trust. And there are a lot of questions and a lot of decisions to be made in terms of deciding which route to take. But assuming you're going to take the route of doing estate planning via a will, and frankly, if you were using a trust, it's just a change of terminology. It's the person who administers a trust is a trustee, and the person who administers an estate is an executor. In terms of choosing who you want to serve in the executor function, people think that, oh, I need to name my child who's a lawyer, my relative who's a lawyer, maybe my financial advisor friend, because they know money, they know law, they know how this stuff works. As a matter of fact, it doesn't necessarily need to be those kinds of people. Often people should name and do name their children. Their children may not be in either of those professions and may not have a clue about the legal ramifications or the financial ramifications of their decisions. What they should do is be knowledgeable enough or educated enough to know, okay, these are things I don't know, and I should call Aaron Katzman. I should call a financial planner. I should call a estate planning attorney or an estate administration attorney, someone who does trusts and estates, to administer this estate, because I can't do it myself. It's very important for a fiduciary, because you do have legal obligations to the estate once you are appointed, or once you take on the role as a trustee of a trust, that you do things correctly. You don't have to be the whiz, but you need to follow, you need to do things prudently. You can't make grave mistakes and expect that you'll be absolved because you didn't know. You need to be able to ask. And as long as you did your due diligence, as long as you do what you're supposed to do and reach out to those professionals who can assist you, you're in a good position. But you do have fiduciary responsibility, and it's important. It isn't a free-for-all.
You said something which I just want to go back on, which is really, really interesting. You can then go ahead and nominate an executor, and the court actually has to appoint them. Are there times where the court goes against the wishes of the deceased and they reject who they had in mind to be the executor?
Yes. So if you name an executor who is not a U.S. citizen, depending on the jurisdiction, because the court is afraid that they won't have jurisdiction over this person, many jurisdictions will not allow the appointment. Sometimes that person needs to get somebody else appointed as an administrator who can serve in the United States. Sometimes they can get a co-executor or a co-administrator to assist someone who is located. Sometimes it's a good idea to name someone who is a citizen of the United States in that role, but the court will want to know, is this person a convicted felon? They want, ideally, the person who takes on this role swears under oath that they will act appropriately. If there is a concern that they will not, the court may very well not appoint that person. It's the same kind of question that you have, although under different circumstances, with a guardianship, where you name someone in your will as the guardian of your young children. Contrary to some belief, you can't, unless a person is disabled, you don't get to be the guardian of your child past the age of 18. As much as you may want to control what they do, when you do appoint nominate a guardian for young children, at the end of the day, the court is going to decide, is this appropriate? If the person is a felon, if the person is 95 years old and they can't be the guardian,
right?
Because the court's going to say, I don't think so. And so it's very important when you're determining who these people should be. Not only are you determining who is the person you want in this role, but is the court going to allow them to serve in this fiduciary capacity, whatever it is?
You spoke about, picking an executor, and when you set up a trust, right, the trustee is sort of the similar thing to an executor. There are, though, we've come across professional trustees, right? So what would go into the decision, I would say, of picking a regular person, a child or whatever, as a trustee, versus actually going the route of a professional trustee?
In terms of choosing to have somebody outside the family serve, a professional, for example, an attorney, that's the first, I guess, group of people that often get requested. It's most of the time people who name professionals or banks, and there are, a lot of the major banks have trust units that manage and act as the professional trustees of trusts. Most of the time, those banks, they have minimum balances that they're willing to serve as trustee of, many, many millions of dollars usually. And the reason why you may want a bank to serve in that role is because some of those trusts, there isn't a one-size-fits-all trust. There are a lot of different types of trusts, and there are some sophisticated trusts. And when there's a lot of money involved, there's a lot more exposure. So sometimes you'll name an entity to serve in that role just to make sure that things are done right. Those entities, particularly banks, charge a much higher fee beyond whatever statutory fees there might be for a trustee, such as in New York, at least, under SCPA 2309, which details the statutory commissions of a trustee. There are additional professional trustee fees if you're going that route of a bank. And those are usually the circumstances where you're going to do that. Sometimes people are not fabulously wealthy and they still want an independent trustee, either because there is family controversy and you don't want to name one child because it's going to upset another child, or they don't get along and you're afraid of extensive litigation just by the mere fact, even if they did nothing wrong, because it's the other sibling and they don't like them. And there's just litigation around that could be avoided. So sometimes you'll get someone else involved. Sometimes it's because you don't have children you trust, or you don't have children at all. And, naming a trustee to make sure things are done right can sometimes be a professional, can sometimes be a an attorney. It's in rarer circumstance that I or our firm, attorneys in our firm, are willing to serve in a trustee role. We prefer family members serve in these roles with proper guidance, and a lot of people, if they really understand what the role is, become more comfortable. But there are certainly circumstances where it isn't a good idea. And part of when we meet with a family, when we're doing planning from the very outset, is we talk to them about the options, the things that they could do, the things that they can't do, and what are the pros and cons of different routes, so that they make a informed decision. We're never looking to make decisions for someone. We're looking to give them the information so that they can make the decision themselves, and to do so properly.
Interesting. So you spoke about, trust and not necessarily trusting children. Maybe we got a little bit of ahead of ourselves, but what are ways, this is a question that comes up a lot, right? What are ways, that you can set financial boundaries with children that you sort of deem as irresponsible? They spend money, right? They don't have any self-control, whatever. What are ways that, you can do to set up the system, right? So that you can, take care of those children and set boundaries with them.
Yeah, so that's a very good question. When we're dealing with trusts built into wills or trusts, what we call, I guess, sub-trusts, when we're dealing, it really depends on the circumstance. So if you're dealing with minor children, for example, and you want to make sure that they, they hit 18 and suddenly they get a boatload of money, and then they go to Las Vegas or wherever they're going, and they just go, and you're worried, oh, I don't know what they're going to be like when they reach that age. They may not be responsible, or they may be somewhat responsible, but not responsible enough to inherit a lot of money, particularly if they're minors and you have life insurance. It's usually people usually inherit life insurance because their parent, especially if it's a term policy, if the parent died young, unfortunately, and that's when obviously you have typically minor children. Falling into a lot of money is not a good idea often, because that's exactly not what the parent was trying to accomplish when they got that life insurance policy. They wanted to provide for their family long term. So one way of drafting a trust is to have certain ages where you get certain increments of and certain distributions at certain ages. So that, often the ages we'll use are, where you get a third of your trust, or you can demand a third of your trust at age 25, half of the rest at 28, maybe the rest at 31. Again, those ages depend on the family. And also, what kind of withdrawal right do you give the minor? Is it that they can demand it, or is there still some discretion given to the trustee as to how to distribute it? So that's one way to kind of scale it. If you have a child who's already older, let's say, who's either special needs and is on government benefits in the United States or elsewhere, potentially, my purview is the United States and New York and New Jersey in particular. But if someone has a child either who's special needs or a family member, someone else who you want to bequeath the money to who fits into that category, or someone who is a spendthrift, someone who doesn't know how to manage money. There are also trusts that can be drafted for those kinds of roles. And there's especially on the spendthrift beneficiary group, there are times when you have to walk a thin line, you have to walk a tightrope to, on the one hand, you want to protect the money from the person. On the one hand, you don't want them to hate you. If every time your child needs money, they need to go call Joe, because Joe's the trustee, and the child's 75 and they're still calling Joe whenever they need money, they can grow to despise their parent. Like, my parent didn't trust me. How could they have done this? Right. So there is a discussion to be had as to, as much as you want controls, to what extent do you need them? To what extent do you want them? To what extent do you need, are you okay with your children getting upset every time they want money and being angry at mom and dad because how could they have done this? So there are situations like that. There's also trusts that are established for asset protection purposes, right, where a child may have creditors, or may eventually have creditors, or maybe is a very successful person in their own right, and they should be receiving their funds in a way that it doesn't become part of their own estate, perhaps for estate tax purposes, for creditor purposes, or all sorts of situations where you might want to consider, how do I go about protecting the child, either from themselves, from creditors, and so forth.
You know, I've seen trusts from people for almost, you might think as a sort of an impartial observer, where the parents are almost punishing the children because they don't like, because the decisions that the children made don't fit with where the parents are. And, you know, I know a couple, I know somebody who went off to be like an artist in southern France, you know, and the parents just didn't like that. So, you know what, they put their money in a trust. Or I see that a lot here, right? Where kids move to Israel and the parents really don't like that. And they just, you know, they set it up. They just, by that decision alone, they view as something which, you know, is a lack of, they're not responsible. So they'll just put their inheritance, they'll stick it in a trust for the kids. So,
Yeah.
yeah, I don't know.
It's a big point of contention. I think
Right.
the most important thing is not so much the decision that's made in terms of these things, because ultimately my job as an attorney is to reflect the wishes of my clients in documents, but it's that they are well informed, that they understand the ramifications of different decisions, and that they make a decision in an informed way. And that's what I'm trying to accomplish when I guide clients in their planning. It's that they do so in an informed way. It may not be what I might do for my children, but that's not my money. So but they should do it in a way that is tax effective, and that provides for their children in a way that, when informed of all the different pros and cons of their decision, they make a decision in that informed way.
And I think that at some point there should be some communication amongst the kid. They should communicate with their children also. I'm not a big, you know, where the kids ask how much we're going to inherit and all that kind of stuff. I think that's a little bit gruesome. There are financial planners who believe, oh, you have to have that the conversation, right? I don't like that. I think it's, you know, I don't think we're looking to kill off anybody. And we don't want to stick the evil eye on anybody and have them die early. But on the other hand, especially when there's going to be trust, and especially if you're doing things differently for different children, right? If you're going to set up a trust for one kid and the other kid's just going to inherit regularly, I think that should sort of be communicated, or else you're really setting yourself up for the siblings. You know, there's gonna be baggage once you pass away, and it's just not going to end well.
Yeah, there are a lot of little pieces that you think are, oh, it's not a big deal. But when you think further into it, and you think about the ramifications of one child having his inheritance or her inheritance in trust and the other one not, and the animosity that you could create between those children that may not have even been there before the passing, ultimately, and I do believe this is the case for most people, ultimately the biggest legacy someone has is their family. And that's why I often see that the biggest fights people have are about heirlooms and about about little things that are not worth very much. It's because you want to set the stage that your legacy is continued with as little baggage as possible. Sometimes it's not an option. Sometimes you think about it and you go through the understanding the pros and cons, and you make the decision that is appropriate for your family, even if that means that you might create hatred or anger between children. There are situations where where people make those decisions, but at least they're making it from an informed place. The other place where a lot of this comes up is in a healthcare proxy, or in with end of life wishes. That's where I think it's very, very important. With other documents, I think it's important to tell your family, by the way, this is where I keep my documents.
Right.
You don't necessarily have to tell them. You may want to tell them where you have accounts. You don't have to tell them how much is in them. But to tell them where there are accounts, so that they're not on a wild goose chase down the road when they can't ask mom, they can't ask dad. But in terms of one of the biggest points of contention that I find is especially in families where people do get along and there's no anger about money or anything like that, is on the end of life care piece. And there are a lot of impacting factors. Sometimes they're, religious, wishes. Sometimes the parents are more observant than the children, or vice versa, and the parents want something done that follows a certain religious edict, because that's what they believe, but the children don't believe the same thing. Sometimes it's just moral or ethical wishes about end of life care and pulling the plug and not pulling the plug and artificial nutrition and things like that, where people think, oh, my kids will figure it out, they'll talk together and work it out. Firstly, you want to have, I believe, even if you name one child as your proxy, the one who's ultimately making the decision, you want to make sure that you have a sit down, and this is what I recommend, especially in functional families where people do get along largely, is have a sit down. Don't have a game of telephone. Have a sit down with your family, even if it's uncomfortable, and don't have it every day. Have a sit down, but make sure everyone's there. It could be via Zoom, it could be in person, it could be a combination. I know, it used to be interviews were done in person, now they're done via Zoom, like this one. But have that conversation and not leave it as a game of broken telephone, where you're telling one kid something and it's their expectation to tell the other kids. And now it's going through the filter of that child. And now the other kids are not hearing it from mom, they're not hearing it from dad, they're hearing it from their brother, their sister. And then when the going gets tough and the emotions are charged in a difficult moment and a decision is made, you then have children like, that's not what mom, dad wanted, that's not what dad wanted. If you only told them, there's still room for disagreement, and every medical situation has its own set of factors and decision making to be made. And I'm not a doctor, but in consultation with the doctor, decisions are made, and there'll always be room for friction. But the more you give your children or your family members the guidance or the understanding of your basic wishes, the more they'll all be on the same page and the less friction you will have. And sometimes it's that friction that lasts a lot longer than any financial disagreement, because one child feels that the parent died and didn't have to die then, and all those kinds of things are really, really important to have the conversation when you're in a good health situation. Don't wait till you're not.
That's great advice. I mean, we both deal with this on a regular basis, right? And my philosophy is that no matter, even in the best of families where all the siblings get along, everybody has their own agenda, right? Some people might need money more than other people. And, especially this comes up when they're inheriting property and things like that, where, you inherit cash, that's one thing, but you have to make decisions. And when decisions had to be made and there are more people, each extra child that's added to the discussion is just another opinion and another, another agenda. It really, really complicates things. So that leads, I think, to the last question. And what are your tips or what do you think is best way to communicate your wishes to sort of head off, we can call it posthumous conflict, right? What ways do you sort of, help with your clients in order to avoid that? Because that's ultimately whatever you mentioned it, and we mentioned it, ultimately your legacy, the biggest part of your legacy is not the money, but I think it's that your heirs get along with each other. Because that's not a given, right? That's really not a given.
It is not a given.
So how do you think is the best way to go about that, so that your wishes are really put into practice and that the kids don't fight at the end?
So number one, when it comes to healthcare issues and end-of-life issues, I really do believe sitting down as a family and having the conversation all in one place, or all at the same time at the very least together, is really important to alleviate that friction as much as you can. It's not perfect, but when it comes to financial matters, a lot of people think, oh, I have 3 kids, so I have to name them all as co-trustees. Sometimes when you have too many cooks in the kitchen, you think you're doing everyone a favor and you're treating them equally, but at the end of the day, there's so much friction as to what to do, and you end up with a stalemate, and then you have a fight over the stalemate, because in your example that you just gave, where you have a piece of real property and one child needs money more than the others, so maybe two children are want to keep the property in the family. That has its own host of questions. Who repairs the roof? When you have a leak. There are all sorts of things that people don't think about. They figure, oh, everyone will just figure it out. They might figure it out in terms of alternating who pays the gas bill. They may not figure it out when your house is flooded and who pays for that. So there are all sorts of issues, but if one child needs the money more and he's adamant or she's adamant, you need to sell this because I need the money, it could create a lot of friction. So you want to be naming, I often tell my clients, even if you have 3 children and you love them all the same, which I hope you do, and they all get along, I still recommend maybe having a succession of trustees, but at least one or maybe 2 people as the trustee. Every case is different, but don't fill the kitchen with lots of cooks, because you're going to end up with more fights, at least anecdotally I've seen this, than if you do it where you have one person in place. Even if someone might be offended that you named that child, that daughter, or that son as the trustee, often people kind of avoid this when they name their eldest or something like that, or as the first person, so no one can really argue they are the oldest, or there's no favoritism question. Sometimes it's because one person is a more adept in the financial world or whatever. Sometimes it's because the person is a business person and they know how to deal with these kinds of decisions. But I think it's very important also to name the person who's going to take everyone's wishes into account best. That if, try to make it work for everybody. There isn't a, buyer. Sometimes there's, it's not just buying or selling. Sorry, selling or just keeping the property. Sometimes it's holding on to it for 5 years and then selling it. So you're kind of accommodating everybody.
Right.
But it's really important that, I don't think it's really important that you tell everybody who your trustee is or what assets you're giving to whom. Let them find out down the road. It's not worth it to create the friction now that might exist then. But if you structure it in a way that everyone's treated fairly, but you also don't have as many cooks in the kitchen, and the people you do name are people who are going to try to deal with all the beneficiaries' wishes and needs most fairly, I think that's the way to go. I also think ultimately the trustee or the fiduciary's responsibility is to the beneficiaries. It's not even to you anymore. It's to fulfill your wishes for the beneficiaries. Their job is to invest in a way that'll benefit the beneficiaries. That's why they need to get proper counsel. They need a proper financial advisor. They need to talk to, if they're going to sell real estate, they need to talk to a realtor or an appraiser to get a sense as to what these things cost and what they're worth and things like that, to do their due diligence. They don't have to be an expert in all those things, but they need to know who to talk to.
Well, that's great. That is really good. Ariel, how can people get a hold of you?
So they can reach us on our direct phone line. It's 914-816-2900. They can reach us by email. We have a website, ejrosenlaw.com. I work with the principal of our firm is actually my father, Ariel Rosenzweig. We have offices in New York as well as in Israel. We deal a lot with expat work as well. But those are definitely ways to reach us. We're pretty responsive. So if you ever need guidance and you're looking for guidance, you can always reach us.
That's great. And I'll put on the notes of the show, I'll put your contact information there as well, so people can just click and they can get you. Ariel Rosenzweig, thanks so much. This was great.
It's a pleasure, Aaron, as always, and have a great night.
Thank you very much. You've been tuning into the Aaron Katzman Show. We speak to you about your life, your money, and your investments. If you like this content, please hit the like button below. If you've not yet done so, please subscribe to both the podcast and to the YouTube channel. And if somebody you know is in the midst of estate planning, and this, I can tell you right now, as somebody who deals with this is good content, and this would be probably of a lot of interest to them if they're setting up their estate plan. Go ahead and share this with them as well. Thanks so much for tuning in, and we'll speak to you soon.